in the record?
Yes, we are.
All right, this is case D561867 with the Hudson matter. This court received a remand from the Court of Appeals. Let me start, Mr. Snyder. And this is no disrespect to you.
Uh-oh, here it comes.
But I am not. This is on for a status check after a remand, which
Yes, Judge.
the court is required to set. I will inquire. Is it now Barrett instead of Hudson?
Yes, my name is Barrett now.
Madam Clerk, you want to note that in the court record? Bottom line, as far as you, Mr. Snyder, and again, I wouldn't allow Miss Barrett as well, but this is on for this court's status check, which is required to set after a remand. That's the only reason we're on calendar today. This court is not building any different or new record. The only reason I was going to have you, and I don't know if your client is available or can hear, is to see if the parties have reached any agreement subsequently, because many times on these, when these come back, by the time they come back, they've agreed to other terms. But if that is not the case, I just need a yes or no, and then I will continue on.
Your Honor, I don't believe they have, but I'd like Ms. Barrett to weigh in on that. My client is not feeling well. I told him I didn't believe that it was necessary for him to be here today, so I asked the court to excuse his presence. Judge, I am always in favor of people making their decisions as opposed to attorneys and judges. So I'm more than happy to agree that we send them to mediation if Ms. Barrett is so inclined.
We have not discussed any changes to anything. He'll text asking to go back to 50-50, but I feel that that's not in the best interest of the children, and that's as far as it's gone.
That's fine. Because this would not be my first remand, Mr. Schneider, candidly, in looking, and I've read it several times, this is a case, and I'm not trying to throw the temporary clerk under the bus. If anything, this court has to take fault because the boss of my department at the end of the day, quite candidly, this was a case where I had a temporary court clerk for this particular hearing, was not the best minutes. Miss Barrett at the time just cut and pasted the minutes. Someone in my department approved them. I signed off on them. Thus comes the appeal. In looking at the last page of their order, and I've had other remands, they indicate the court needs to set an evidentiary hearing. They're very clear what I need to do. All they indicate is there was simply not enough findings in the order that was issued, and I absolutely agree. I agree in looking at it. It's ridiculous, and I'm upset at myself for letting it get through my department in the manner that it did, given what was in the order. And I'm not blaming you, Ms. Barrett, because you're not an attorney. But I absolutely, given what was in the underlying record, will be able to issue the further findings as they've indicated and the things that they are requesting. And again, had they indicated that I had to have a hearing to decide this thing, I would, but that's not going to be the case. So pursuant to, again, the only reason I had the hearing today is to see if the parties had stipulated otherwise. Clearly, that's not the case. Ms. Barrett thinks it's in the children's best interest to keep it the way the way it is. Under EDCR, give me 1 second. 1.90 subsection A, subsection 4. I'm going to take the matter under submission pursuant to the remand and issue an amended order no later than 21 days after today. If, Mr. Schneider, you contact Ms. Barrett and come to some sort of any other agreements and reduce that to writing, you can feel free to do so. Just contact my chambers. Otherwise, I will issue that amended order within the 21 days.
Okay, I just want to inquire to Ms. Barrett whether or not she's a retained counsel or is represented by anyone.
I'm not routine counsel.
And would you accept a phone call from me? I didn't hear it, but I think I
There's
saw
an
it.
amended order. Oh, yes,
Okay.
I will.
You. All right, Ms.
Again,
Barrett.
if that's going to be the case, I'm going to kind of delay even looking or working on this for about a week. So unless I hear otherwise, and we'll end up confirming with both parties, then the court will work on the amended order pursuant to the order of remand.
Okay, I just.
So what is
Go ahead, I'm
amended
sorry.
order? What is an amended
Ms.
order?
Barrett, listen, I know you're not an attorney. I cannot sit here and give you a legal dissertation. Candidly, I had a temporary clerk. They did not put a lot of findings in the minutes. I realize you cut and pasted your order, your handwritten order from the minutes. The Court of Appeals simply indicates that I need to put more findings of fact in that particular order that was issued, and that's all that they've indicated thus far. So that is what I'm going to do within the next 21 days, unless you and Mr. Schneider can agree otherwise.
Okay, Judge, Ms. Barrett, I don't want to put your number on the record, but do you still have the number that begins with the area code 760?
She nodded yes, Mr. Schneider. I think you looked
Oh, I
really-
missed it, Judge. I'm sorry. All right, thank you, Your Honor, and I appreciate the time to get in touch with Ms. Barrett. I will do that by, what's a good time to call you, Ms. Barrett?
And call me after this this meeting if you're available.
I'll call you shortly thereafter, Judge. So I'll get back to you, Your Honor, early next week if things are going to change. But I will definitely follow up. But I appreciate the time. Thank you.
All right, guys, have a good day. Stay safe and healthy.
Thank you, Judge. You too.